also want to add a reminder to everyone here that the dialogues will always have a friend with the American Red Cross. We are proud to support its purpose and mission, and we will continue to do so in the future. Secondly, I wanted to add that this is my first time at the dialogues. This is not the first time the American Red Cross has been here, but it is my first time, and I have been personally impacted by what I have witnessed. I admire everyone's intellect here. I have gained so much knowledge. I have been given new perspectives. And half the battle of progressing a new world is receiving new perspectives, internalizing them, and taking them for what they are and moving them forward. Finding the good in them, discussing disagreements. That is the only way to true progress. I also wanted to add one other thing. There are many people in this room that I've met for the first time, but I have known you far longer because your work has impacted many people. In the office, of course, but also in a small rural town in the state of Iowa, you impacted me. So I must personally thank all of you. It is a true honor to be here. I also want to add one other thing. Your passion for the rule of law and your dedication to humanity is probably the most profound thing that I've witnessed in many of these types of conferences that I've attended. That dedication to humanity is something that is not only shared by me. I was told to also extend my gratitude from our senior legal advisor, Thomas Harper, who was unfortunately not able to come. But that's why we're proud to support it, because the American Red Cross's whole goal is an organization dedicated to humanity, to the call of humanity. The call of humanity for the American Red Cross is to alleviate suffering wherever it is found and ensure respect for the human being. I think that is also being achieved here tonight. I also want to lastly add that the name bearer for this lecture, Clara Barton, would be extremely proud of the work that's being done. And so with that, I want to introduce our speaker, Deputy Prosecutor Nazhat Shameem Khan.
Thank you so much, Christian, for that short introduction and for following the instructions on keeping it short. Friends and colleagues, it's a real pleasure to be here, and I'm sorry, most after-dinner speeches are supposed to be light and amusing. This is not going to be light and amusing, and I apologize in advance. So, first of all, I'm honored to speak on behalf of the ICC Office of the Prosecutor at this gathering of current and former chief prosecutors from the international criminal courts and tribunals and other eminent legal experts. Following my inauguration as a deputy prosecutor of the ICC in March of this year, my presence here is a first, and I wish to thank the organizers, notably Michael Scharf and David Crane, who is of course not here, for inviting me. I am especially honored to have been asked to deliver this year's Clara Barton Lecture, which I understand has become an institution of this forum and invites us to reflect on the beginnings of international humanitarian law and its perennial purpose to limit the suffering caused by warfare and to alleviate its effects on human life. Before I begin my substantive remarks, I wish to recognize and extend my greetings also to the chairperson of this year's roundtable, former ICC prosecutor Fatou Bensouda. I admire your efforts throughout your rich professional career and during your tenure at The Hague, in particular those relating to the development of policies on sexual and gender-based crimes and crimes against children. Fatou, you're not supposed to clap for yourself. These are themes which are very close to my heart, and of course to the vision of the prosecutor, Karim A.A. Khan, QC. And I will revert on this matter during these remarks. This year's theme of the roundtable reminds us of the past atrocities that led to the establishment of international criminal courts and tribunals, and the wider contemporary efforts of the international community to address atrocity crimes. Current events harrowingly demonstrate the need to cling to the law and apply it in a practical and effective way as an anchor for stability and security in the world. Unfortunately, too many children, women and men, young and old, are living in terror in different parts of the world. We see on a daily basis the suffering of citizenry. In such a time, as the prosecutor has said, the law cannot be a spectator. The law is meant to protect and uphold principles that are essential for humanity. But I believe that there is hope, because whilst we see the devastation of people's hopes and futures, events in Ukraine and elsewhere have also brought into stark relief that we need to have a reawakening or reinvigoration of the law. And I would like to take this moment to reflect on the evolution of the ICC and the rule of law more broadly, recognize the progress that we have made, and shine a light on the present challenges that we have to overcome in the everlasting pursuit of justice. On the 1st of July this year, the International Criminal Court commemorated the 20th anniversary of the entry into force of its founding treaty, the Rome Statute. The establishment of the world's first permanent International Criminal Court with jurisdiction to prosecute individuals responsible for the most serious crimes under international law is an important achievement for the international community and an incredible milestone in the global fight against impunity. As I have heard Fatou Bensouda say on several occasions, one of humanity's proudest moments must surely be the creation of the International Criminal Court against all odds. The ICC is a dreadful testament to the horrors of mankind and our collective will to give concrete expression to the maxim of never again. Yet that commitment must not ring hollow to haunt the memories of victims of the past or to abandon the victims of tomorrow. The Holocaust, the killing fields of Cambodia, the years of apartheid, and the genocide in the former Yugoslavia and Rwanda are not just evils of the past, but atrocious examples of what human beings are unfortunately capable of at any moment if the international community does not interfere. We must remember that the international criminal justice system, as we know it today, was hard-earned, not given. No matter how far we advance on our path towards accountability and universality, justice will only be as strong as its advocates. And the Rome Statute and the ICC are testaments to what we can achieve through multilateralism and a shared global abhorrence for crimes against humanity. Clara Barton and her work, which we are honoring today, are legacies of this important global determination. During the American Civil War, instead of being a bystander, Clara Barton petitioned leaders to gain access to the battlefield in order to provide care and supplies to wounded soldiers and those in need. The pain and suffering that she witnessed galvanized her to action. In 1881, she founded the American National Red Cross and successfully advocated for the ratification of the first Geneva Convention by the United States. I would like to take this moment to acknowledge the important and effective work of the American Red Cross and of international Red Cross and Red Crescent societies. The work, especially of national societies, including the American Red Cross, demonstrates the importance of international humanitarian initiatives and work on the ground with affected communities in conflict zones. Indeed, when the first Geneva Convention was adopted, its strength was its focus on protecting those who are victims of conflict, who must never be the target of war, and who look to humanitarian action as their only resource and recourse. The Geneva Conventions continue to be relevant and pivotal in humanitarian action during conflict, violence, and war. The Red Cross and Red Crescent serve without judgment the most vulnerable and protect them from the worst human rights violations. Following the historical developments relevant to the body of IHL and ICL as we have come to know it, today it is again time for a growth spurt of international law. Every single one of us can and needs to participate in this common cause to resist intolerance and unrestrained violence. Across continents, we must individually and collectively endeavor with renewed commitment to view the sufferings of our brothers and sisters and of children as if it were, God forbid, the suffering of our own families or those we love. The tears and the pain that they suffer should galvanize us to action. Let me turn to the Office of the Prosecutor. In addition to the 20th anniversary of the entry into force of the Rome Statute, our office has just completed its first year under the leadership of Prosecutor Karim Khan, QC. It has been a busy period, during which the office has worked hard to implement the prosecutor's strategic vision for the office's functioning. We are working under a new structure with, as a critical feature, the allocation of situations and resources to two central pillars under the responsibility of the two deputy prosecutors, Deputy Prosecutor Niang and myself. Under the prosecutor's overall guidance, we directly oversee the work of the office's unified teams working on the various preliminary examinations, investigations, and cases, while benefiting from the support provided by different specialized units, such as forensics, security, gender and children, and external affairs. We are also working to enhance the office's capability in financial investigations and the tracking of assets. The purpose of the restructuring is improved efficiency in investigative and prosecutorial activities. However, it is also to ensure that the work we do is conducted in a safe and respectful environment. We are already a diverse team in the Office of the Prosecutor, but there is always a need for greater geographical representation. Having staff of all genders from all regions of the world will inject even greater linguistic, cultural, and substantive expertise into the work of the office, bring many benefits at the investigative and trial stages of proceedings, and underline the common heritage and common ownership of the law that we apply. The court and its organs are stronger if there is a strong sense of identity with all parties and all regions. In turn, all parties, regions, and legal systems will have the ability to shape the jurisprudence and character of the court and its decisions. Diversity in participation must continue to be one of our greatest strengths. As a national from Fiji, I should add here that the court does face a challenge in receiving an equitable number of applications for job openings from certain regions, in particular the GRULAC and the Asia-Pacific regions. In the same way, we can observe also a need to enhance the universality of the Rome Statute and encourage more accessions from states, for instance in the Asia-Pacific region in particular. Within the limits of my function, I am committed to promoting the Rome Statute's reach, and your ideas in this regard would be welcome. As another key feature of the office today, the prosecutor is committed to the effective implementation of both policies on SGBC and on children, knowing that this is the only way that we can institutionalize effective responses to pleas for justice of the most vulnerable victims of crimes of atrocity. An ongoing challenge that is foreseen in both policies is the need for building capacity in speaking with victims of such crimes and presenting the evidence in court without re-traumatization. This continues to be work in progress and is the focus of training and capacity building at the office this year. Avoiding re-traumatization of victims and survivors by prioritizing their interests and needs was, amongst others, an important topic of conversation at the conference organized by the Netherlands in cooperation with the European Commission and our office on the 14th of July 2022. The Ukraine Accountability Conference was more broadly aimed to deepen the coordination process in the ongoing investigations of the international crimes committed in Ukraine and to develop more effective mechanisms as a blueprint for the future and other situations. This brings me to the issue of complementarity. The office is focused on the effective discharge of its mandate under the Rome Statute and collaborates and coordinates closely with other accountability actors at the domestic and regional levels to ensure that there is no impunity for Rome Statute crimes. We recognize that the most powerful and compelling way to show what has happened to victims and survivors is ensuring that their voices can be effectively heard through a justice process that caters for their needs and respects their environment. It is for this reason that the prosecutor has emphasized the strategic need to work closer to affected communities. Already through visits to situation countries, the office has made efforts to meet with government representatives and to talk to victims and civil society representatives. The best way of communicating effectively the meaning and purpose of the law is in the field and with the stakeholders. We are enhancing our regional engagement and seeking to increase field presence to build more meaningful dialogue, to assess developments, to collect evidence, and to solidify cooperation at the domestic and regional levels. For the Office of the Prosecutor, it does not matter whether crimes of atrocity are prosecuted domestically or at the ICC. Indeed, domestic prosecutions are often preferable. Such prosecutions are owned by the state and its judicial system, provide support to national law enforcement and judicial institutions, and increase understanding of Rome Statute offenses by the people on the ground. The dialogue between the prosecutor and a situation country is in itself part of a valuable journey to strengthen the universal values underlying the Rome Statute. In my own previous position as President of the Human Rights Council and as the Fijian ambassador to the United Nations in Geneva, I saw the value of an inclusive, consultative, and respectful engagement with all countries in delivering positive human rights outcomes within national jurisdictions. A classic example of such engagement is the Human Rights Council Universal Periodic Review mechanism. This mechanism enables a review of the human rights journey of every member state of the United Nations in a peer review process through recommendations and scrutiny by every other country. The engagement is intended to make changes on the ground and has had that effect because the review is cyclic and countries must deliver on the undertakings that they make to their peers. The approach adopted by the prosecutor to increase dialogue with all countries, including situation countries, is based on the conviction that to build a universal respect for international criminal justice and the Rome Statute, we must engage more, whilst maintaining and strengthening the mandate of the Office of the Prosecutor. An example of a situation where the Office has worked closely with national authorities and with relevant UN bodies already since the days of Prosecutor Bensouda is the Central African Republic. In addition to the more regular cooperation that the Office has been receiving for its own investigations and prosecutions, it has also been contributing to the important mission of the CAR Special Criminal Court. Since the SCC started operations, our office has received from it a number of requests for cooperation to share information and documents that we collected for our own investigations. We have held working visits with magistrates of that court, and we continue to assist in responding to their judicial needs. We endeavor to emulate such collaborative efforts in other situations. The announcement by the prosecutor on the 3rd of November to proceed with investigations in relation to the situation in Venezuela was coupled with a joint signing of a memorandum of understanding with the government of Venezuela, strengthening the basis for dialogue and cooperation. Since then, the office has sought to explore modalities to strengthen cooperation with the Venezuelan authorities and to facilitate technical assistance under the framework of the MOU, while progressing its independent, mandated activities. This included a second official visit by the prosecutor to Venezuela in March 2022, during which agreement was reached for the establishment of an office in Venezuela in support of cooperation under the framework of the MOU. The office has already engaged with other relevant actors working in the region in the field of the rule of law and capacity building, including from the UN. A final example I will provide showing the value of enhanced partnerships is the situation in Ukraine. The gravity of the situation means that all actors, national, regional, and international, are strengthened in their individual efforts when they work together. Allied with enhanced presence on the ground, our office is seeking to make tangible progress in the near term, mindful that our evidence collection efforts must have a purpose, not to gather dust on shelves for historical interest, but to uphold the rights of individuals and their right to be protected from atrocity crimes. The office is also engaged in close coordination with the Prosecutor General's office in Ukraine and a variety of international, regional, and domestic actors that are also active in relation to the collection of information and evidence. Innovation serves as an important accelerator to activities in the field. For the first time, the office is participating in a joint investigation team under the auspices of Eurojust to more effectively share information with domestic prosecution authorities. The office is working with states on deployment of forensic missions through a rotational model of mobile teams using the cooperation with the Netherlands as a blueprint. The office is investing in modern technology in partnership with Microsoft and with generous financial support of other partners to enhance our evidence gathering and analysis capacity and to make available more effective information to all other accountability actors. The office has developed guidelines with Eurojust for civil society and for domestic authorities in relation to the gathering of information to avoid over-documentation and unnecessary re-traumatization of victims and witnesses. These are all lessons we have learnt from the past, whether drawn from Cox's Bazar, from Iraq, or from Syria. These efforts and strategies will enable the Rome Statute system to effectively become a two-way street, allowing the office to work as a hub in the center of international criminal justice, as opposed to a detached apex, because universality can only be achieved in cooperation. Before bringing my remarks to a conclusion, I wish to emphasize that the law has a crucial role to play in addressing and preventing atrocity crimes, not in isolation, but with other measures, diplomatic, political, economic, or otherwise. The law cannot be idle, nor relegated to a secondary position. We must maintain the new momentum that we have created, building on our collaborative spirit to deliver a measure of accountability in Ukraine and in other dire situations that demand our attention, and where we must inject a similar focus and urgency. The lives of those that look up to us must be vindicated by concrete action the world over. I thank you all for your attention, and I look forward to engaging in dialogue with you. Thank you very much indeed.
was wonderful. Thank you. One more time. Okay. What's going to happen next? Throughout the course of the evening, pardon? Oh, well, would you like to entertain some questions? Well, do we have some questions? That's great. Now we've got the commitment to take some questions, so we need some. There we go.
Shall I come on?
Please.
So, thank you so much for your remarks. Growing number of cyber attacks around the globe, and we know there have been massive cyber attacks into Ukraine this year, mostly prevented, but there's a huge list of them. And of course, the cyber attacks in Ukraine go back years. We haven't yet had a catastrophic cyber attack, but certainly the capability for a purely cyber attack is the same. It can cause physical damage just as much as a conventional attack, loss of blood, and clearly could be the ICC draft infection. So I have the privilege of working with Liechtenstein and the Council of Advisors on the Rome Statute of Cyber Warfare. And I wonder just if the office is interested in developing capacity in this area. I believe there are now 4 attorneys assigned to work in this area. Matt Cross of your office was part of our team, and we very much welcome his expert participation. But if you could just comment, it seems to be one of the ways that crimes are starting to be perpetrated or are being perpetrated, have been, and just if you could comment on your office's approach to cyber.
Thank you very much indeed. And of course, I'm asked a question by an expert because one of your articles addressed the growing role of cyber behavior in the context of crimes against humanity, especially cross-border. So the answer is yes. We are already working on building capacity. And in addition to the capacity we're trying to build in relation to cyber attacks and conduct, as I've said, we're also looking to enhance the work of the Financial Investigations Unit. And I think they're very, very close connections. So the answer is yes.
Years, there's been a lot of review of the internal expert review mechanisms. And I was just wondering, from your perspective, what your office is doing in terms of implementing the suggestions that have been made. Totally, there were about 300, but specifically to the OTP.
So the independent experts report is something that has really guided change in the Office of the Prosecutor. The prosecutor himself is absolutely committed to implementing recommendations in relation to the workplace, particularly, but also in relation to the way that we are processing situations under our auspices. So in relation to workplace culture, one of the most important imperatives is to create a workplace which is respectful, inclusive, and dignified. And for those who think that there is no connection between the way we treat each other at work and the work we do, I have to say that if we treat each other with respect within the workplace and in a way which is inclusive, then we are more likely, I think, to understand complementarity and inclusive and respectful conversations outside the court. I think there is a direct correlation. So one of the very important mechanisms is to ensure that people are courageous enough to express dissent. So when we have a meeting with a large team, often we find, and of course this is in every workplace and not just ours, often we find we only hear from 1 or 2 voices, and yet perhaps the wisest person in the room is silent. And so we have tried to find ways to speak only to some people and to separate them from the authority structure, and to really hear what they have to say. And one of the very interesting innovations is that we, both I and DP Nyang, have adopted an open door policy every Wednesday afternoon, where anyone at all in the Office of the Prosecutor in our pillars can come and see us. It doesn't matter who you are and what you do, the door is open and I want to hear from you. And that has become a very effective way of hearing voices from people who normally would not say anything in a team. And it's extraordinary. It was through this process that I got from quite a junior member of the office an amazing policy on analysts and sexual and gender-based crimes, which I hadn't seen before. And that's now being considered by the Gender and Children's Unit. So we have to devise mechanisms for transformative change. And I do have to say something really at a personal level. As a woman, I was the first woman prosecutor in Fiji to be appointed. And I recall when I was appointed that I was told by my male colleagues that we've never had a woman before, this is a trial, and we had to have a meeting to see if we were ready for women. And then for many, many years, of course, I then experienced trials. Are you strong enough to do sexual and gender-based violence crimes? Can you do corruption? Are you ready for murder? And so when you've been through that kind of testing experience as a woman, you do remember, when you become a senior woman yourself, what it was like. And you draw on your own lived experiences to ensure that mechanisms exist in the office which will prevent such discriminatory behavior for all other women. And not just for women. Anyone who gets bullied or harassed or sat on, you know what it's like because you were there. So it's been a pleasure to work under the prosecutor in really implementing transformative change. He is determined to lead the charge on this. And it's not just about harassment or bullying. It's also about integrating equality and respect through the performance appraisal system. So in appraising performance, we are asking managers, what have you done to ensure that you are creating an equal workplace? And then it is an expectation of the office. For this, leadership is absolutely necessary. This is something that can only be led by those at the top. So it's a management responsibility, and we take it very seriously. In relation to the IER's recommendations on delay, on the way in which we are treating situations, on preliminary examinations, on scrutiny, on supervision, we have devised ways in which we are trying very hard to bring some situations to a close, whilst really scrutinizing the ways in which we can strengthen evidence. In addition to that, we are introducing a computerized case management system, which is intended to reduce delay and again increase scrutiny and supervision by managers. The whole process of appointing the heads of unified teams, and that is by putting prosecutors and investigators together in one team under the supervision of the HUT, means that we don't have people in the team answering to different leaders. Everyone is answerable to the head of the unified team, and the purpose of this team is to implement investigations and prosecutions in relation to that situation. And lastly, the IER was very strong on increasing field presence. We are increasing field presence. You'll see that in Ukraine. We also have opened an office in Cox's Bazar. We are increasing presence in Sudan, and we really are very focused on ensuring that our investigators and prosecutors are on the ground, working with communities and stakeholders, and trying to understand the community and the society within which we are prosecuting. So I think that's examples of some of the recommendations. Some of the recommendations have to be phased in because, as you've said, there's a large number, but certainly there's certainly a lot of political will from the leadership to implement them. Thank you very much.